Hello and welcome. My name is Zach McCormick, and today, in association with the Florida Bar and the Henry Latimer Center for Professionalism, it is my honor to present a new piece entitled Only Mentors in the Building. Our guest today is Harry Hackney. He is one of the senior partners at Campione in Hackney. Joining him is his senior associate, Matt Frey. And today we're going to be discussing how the profession has been shaped over the last, several years and the changes that we have seen. So without too much further ado, Harry, when you were approached to do this piece, what was the first thing that jumped to your mind on the subject of mentorship and the younger generations of lawyers that have been coming into the profession?
First thing that jumped to mind, I think mentorship is important. I'm not sure that young lawyers get enough of it, in part because everybody is so busy these days trying to bill hours and make money, including, the more senior lawyers in a firm. And of course, I think the larger the firm, the more likely that is to be. So I guess that's probably the first thing that came to mind, is that it's much needed, but probably rarer than it should be.
So when you say the focus is on billing hours, is it safe to say that new attorneys aren't getting the sort of feel of the courtroom the way that they once were?
Yeah, I have actually an excellent example of that. I was board certified in civil trial law for about 10 years. And because these days it's hard to get trials, I would end up attending the 1 week long trial law seminar, which could stand in for the jury trial that I did not have. And I was aghast to discover that in a room of, maybe 18, 20 attorneys, ranging in age from, probably their middle to late 20s to their middle to late 30s. In the one room I'm thinking of in particular, there were actually two board certified civil trial lawyers in the room, myself and a fellow from Tampa who also needed the 1 week seminar to make up for his lack of a jury trial during the preceding 5 years. And I was flabbergasted to discover that the young attorneys in the room, that really the only two people in the room that had ever tried a jury trial at all or tried a case on our own, were the two board certified civil trial lawyers who were we were in our 60s, I think, or certainly late 50s. And none of the other lawyers in the room had ever tried a jury trial. And in fact, most of them had never tried a case by themselves. And, I said, well, don't you get an opportunity to cross-examine a witness or at least do direct examination of, somebody friendly? And they're all like, no. The only thing I get to do is carry the senior partner's briefcase, and I'm not allowed anywhere near a witness in a trial. And, I just couldn't believe that. And some of them had been practicing law for 10, 12, 15 years in large law firms, large litigation law firms. And you couldn't see it there, but I was doing air quotes, large litigation law firms, and no trial experience to speak of. And, I was just thinking back that in the mid 80s, when I started practicing law, that my first jury trial, one of the partners in the law firm I worked for said, I'll go with you and help you pick the jury and, get you started. And, he helped me pick the jury and all that. And about, midway through, he goes, you're great at this. I'm going back to the office. And he left me in the courtroom with a jury half picked and went back to the office for the day. And, that was my first jury trial experience. But before that, I had been in trials with, older attorneys and things like that. Same thing. My first appearance before the 4th DCA, it was, I said to the day I got sworn into the bar, I went to the partner whose brief I was working on, and I said, I finished that brief. I need your signature so we can file it. And he starts to sign it. He looks at me and goes, hold on a minute. Didn't you get sworn in this morning? And I said, well, yeah, as a matter of fact, I did. He said, well, then you're a lawyer. I said, yeah, I guess I am. He goes, you signed it. You wrote it. So I signed the brief. And then when it came time to argue it, I said, do you want to go with me to the 4th DCA? And he said, nah. North on I-95, exit at PGA Boulevard, it's on your left. And that was my first, other than watching, I think, a Supreme Court oral argument when I was in law school, that was my first experience in the 4th DCA, other than going there to be sworn in.
Well, so now let me ask you this, because I'm going to segue over to Matt here just a sec to kind of get the flip side of this mentorship mentee sort of viewpoint. But my question is, do you think your experience made you a better lawyer?
Yes, definitely. Absolutely. Because I got to try things all the time. I mean, those were my first, but they weren't my last. I cut my teeth, so to speak, trying lots of like tenant evictions and things like that. Their county court, the partners didn't want to be burdened with that. And so it's here, you go do it. And, you get a lot of experience and practice doing things like that. Now, as you might have gathered from the stories I just told, nobody was holding my hands, so I don't know how much mentorship I was getting, but I was getting the opportunity at least. And I think there's more emphasis on billable hours, and there was quite a bit back then, don't get me wrong, but there was also certain tolerance. It's kind of like the difference between helicopter parents and the way I was raised. There was more tolerance for, here, kid, go do it. What's the worst you can do? You screw up somebody's tenant eviction, oh well. And I don't know that there's quite that same attitude today.
It sounds like you're saying that the mentorship in some respects happened by staying out of the associate's way.
A little bit, that's true. Although, I think if I had questions, people were available and would talk you through those things. You got some involvement that way, but they also weren't afraid to let you do things. And
not afraid to let you do things.
There seems to be this fear of actually letting anybody, who hasn't been practicing for 20 years do anything.
Now, you've been practicing 38 years, I think. Is that right?
Yes, 38. It'll be 39 this October.
So it sounds like you've kind of seen this progression. You've gone from what you might call just the pure paper and in court to the now almost purely digital, and also via, for example, Zoom or other remote means.
Oh, yeah, this is all science fiction. The classic example I use is if somebody came in to be incorporated back in the day. And keep in mind, when I first worked as a law clerk, we used IBM Selectrics. So I can remember the introduction of the computer. We actually had carbons in the files.
So just for the benefit of our listeners, okay, the IBM Selectric was, in fact, cutting-edge typewriter technology, and carbons probably, here, you tell me if I'm wrong on this, carbons were carbon paper. That's what that was referring to, right? So as you would press the ball of a pen down, it would literally push through the top sheet into the second and even third sheet, and that would actually make copies instantly because it was copying what you were handwriting, right?
Yeah, and in the case of what I was describing was the carbon paper would be in the IBM Selectric. Sheet of typewriter paper, carbon paper, sheet of typewriter paper. And so when they hammered on the Selectric, and, a good secretary could make an IBM Selectric sound like a machine gun on full automatic. As they typed, it would create a carbon copy of the pleading that they were typing. The carbon copy would go in the file, and the original would go off to the courthouse. And if somebody came to you to incorporate, you had to get at least 3 potential names because you didn't know whether or not the name would be available, and you couldn't go on Sunbiz and look it up. Your assistant had to call Tallahassee and sit on the phone for 3 hours until she got somebody on the line who could say, yes, that name's available or not. So, things have changed tremendously in that respect.
Wow. Well, Matt, you've heard a little bit of, how it once was done, and you've seen a lot of how it is done now. Your time with Harry, of course, has gone back to 2013, I think, right?
That is correct. Under Harry's tutelage since I got out of law school in 2013.
Okay. So you would be the mentee in this situation, it sounds like.
I would be the lucky mentee. That is correct.
All right. So
Prefers the title abusee.
So with your experiences, you would have still been taught things like legal research in the law library, using physical copy, using real books, right?
That's correct.
All right. And so you kind of came in as like in one of the first waves of lawyers to practice in the digital age. What viewpoints do you have on what Harry's been discussing with regard to this question about the ability to have the chance to get out there and actually try your hand at the practice of law?
I think for me getting into law, my partners for my firm, Harry and David, they definitely provide that opportunity, right? So the, sink or swim approach, if you wanted to have it that way, right? Throw in the deep end, go select a jury, go do those things and kind of see how it turns out. I think I was the more cautious for that approach because of understanding and kind of respecting the work that goes in with the client and what's on the line, and just being unsure of my own capabilities for many years. Even though I think I would have that confidence and faith from the guys, it was just more of I would either walk in slowly through the shallow end and kind of immerse myself in it for as long as I thought I needed to before, day one signing an appellate brief or going to select a jury. I would just be more cautious in that respect.
And I've known you for a little while, actually, so I remember kind of when you started. I think you came in maybe 1 or 2 years after I got my law license, and one of the things that I do remember you mentioning was how accessible Dave and Harry have made themselves. So, you talk about the sink or swim part, but would it be fair to say that for you, being able to kind of walk down the hall, knock on a door and say, hey, can I ask you a question? Would it be fair to say that that was a big part of how you've developed as a lawyer?
Yes, always kind of an open door policy. Even having Harry schedule Harry in for this particular interview, right? I was just, Harry, can you come talk about mentor-mentee stuff? Sure. It doesn't matter. He'd make the time, and that's the kind of guy he is.
So, Harry, when you've got someone like Matt who's just kind of walking in, how does that make you feel? And before you answer that question, understand one of my first experiences with because I started my first position as an assistant public defender, and their chief assistant public defender, Bill Stone, used to have a saying, and it was pretty straightforward and self-explanatory, and it was, go read a book. And the truth of the matter was, he was always there watching carefully, to kind of make sure that the neophytes, did actually do right by their oath and by their clients and so forth. But when you have someone kind of knocking on your door, taking you away from a project, they need to know the information. How do you feel that interaction should go? Is it the same every time? Do you take a nuanced approach case by case, or do you kind of just have a one-size-fits-all approach?
Well, first of all, I knew Bill, and Bill was not wrong. And there are times I think that I should start saying it out loud. I really don't mind, and in a lot of circumstances, it's a chance to actually maybe even save hours of time on behalf of a client that might be spent chasing down rabbit holes and trying to figure things out. I may not always know the answer because frequently the discussion goes something like that. Well, geez, that's a good question. 15 years ago, the last time I had something like that, blah, blah, blah. But I don't know if the law has changed since then. You might want to look it up. But at least I can, point them in the right direction. Now, not everybody is me, for better or for worse. And, I would say to anybody that maybe has somebody like Bill, there's a lot to be said for getting some idea of what's involved, or seeing if you can't find some guidance or direction, by looking it up, because you learn a lot from that, as opposed to being spoon-fed. I don't think you learn as much being spoon-fed as you do when you try to find things out on your own. It's certainly, things need to be updated. When I was a young lawyer, I remember one of the newer hires, I think he was a law clerk at the time, coming to me and saying, you used to work with Howard all the time, and everybody says, Howard, you always knew what Howard wanted, and you worked great with him. And he goes, and half the time, I don't even know what the heck Howard's talking about. Can you help me out? And I said, yeah, sure. Here's what you do. You go and you take what he tells you, and you go and you do all kinds of research and stuff, and then you come back to Howard and you go, yeah, Howard, here's what I got. I don't know if it's what you're looking for or not, but, we got this, we got that. And then Howard goes, oh, yeah, that's perfect. Or he says, no, that's not what I wanted at all. I wanted you to do, blah, blah, blah. But I knew enough at that point. I started from nothing. But by going and doing that research, I knew enough at that point that I could understand what it was that he really wanted and what direction he wanted me to take, as opposed to where I had begun, not knowing anything. So, I really don't mind because, like I said, it saves a lot of time, and sometimes it helps to point, the younger lawyer in the direction you want them to go. But there's also a lot to be said for, doing some of that yourself so you know the direction that you want them to go in.
So it sounds like there's this combination then in your office of the need to have a new associate both understand the concept, but also the ability to find the answers to help them understand new concepts in the future.
Absolutely. And again, I think things stick better and longer term, from the learning experience as opposed to, the old experience is the greatest teacher. Well, if you never go and do the research yourself, I don't think it sticks with you quite the way it will if you spent 2 hours reading the cases and figuring out what the law is in a particular area.
That makes sense.
Plus, again, unless I've done it recently, things could have changed and I could be wrong.
Right. And we've seen pretty big changes recently in the rules of civil procedure and elsewhere. So that makes good sense. And it sounds to me like you're pulling in kind of the cumulative knowledge of the experiences that you've had, because I know that you were a lawyer in South Florida for a time. You've worked in what we might call big law. And, now you have a very well respected practice with, what is it? Is it 3-4 attorneys that you've got working under your roof now? 4 attorneys. Okay. So you've kind of had the chance to see a pretty diverse variety of different law office structures. And can you kind of give us an idea, especially for the newer lawyers who are starting to kind of ask questions for themselves? Do I want to go towards big law? Do I want to go towards a boutique practice? The kinds of things that you found to be useful in trying to make those decisions?
Yeah. I think as a law student, I don't know if every law student's like this or not, but, I think it was kind of like, oh boy, I want to go work for a really big law firm. That's the pinnacle, right? One of these blue chip law firms. That's the thing for me. And, as it turns out, I didn't have the grades for that anyway, so that was not a problem. And the law firm I went to work for was Tripp Scott, Conklin, and Smith. And back then, when I started working for them, it was like 7 or 8 attorneys. So given the fact that the vast majority of law firms in Florida are, 1, 2, 3, 4 lawyers, I guess it was larger than average, but it was certainly smaller than the big blue chip firms. And although they had some pretty blue chip clients, they had some pretty good sized clients back then. And but the thing I learned fairly early on practicing in South Florida, and because of where I worked, encountering a lot of the young lawyers who were big firms like Greenberg Traurig. I remember a conversation with a Greenberg Traurig lawyer that was basically, we get up, we put on our suits, we go to work, we come home, we take off our suits, we go to bed. We do that 6 days a week. And they were teasing the senior partners that they needed to build them a dormitory on top of the parking garage so they wouldn't have to go home and waste time. And, you heard all kinds of stories, somebody at Fowler White in Tampa sleeping under his desk. So you heard all those sorts of stories. And, I got to meet lawyers that did things like that. And I realized, yeah, that's not for me. I would never want to sleep under my desk. All the money in the world doesn't do you any good if you don't have time to spend it. And so these guys were, making tremendous salaries and everything, but didn't have any time to spend their money, never saw their kids, things like that. And so I, in terms of deciding what you want to do, I would say, look at what's important to you. Do you want to have time to yourself? Do you want to work every weekend or not? If you don't want to work every weekend, if you ever want to have any children, do you want to spend any time with your kids? And decide accordingly. Generally in smaller firms, I think you're going to have more control over your time. You might not make quite as much money, but you'll have more time, and there's something, a value associated with that, and usually have more control over your time in terms of when you can take vacations and whatnot. I've never been one of those lawyers. I don't know if this is the case among younger lawyers, but certainly among my lawyers my age or older, you'd run into the ones that would brag, I haven't taken a vacation in 14 years.
Like it was the badge of honor.
Leave my practice. And I'm like, yeah, you can. And the fact that you haven't in 14 years is on you. It's possible. Well, how do you do it? How do you manage to take vacations? I announce that I'm gone. Deal with it. I'll be back in a week.
So you're touching on something that actually I think resonates, because I follow a lot of forums and things like that, with newer lawyers, just to kind of keep a finger on this pulse. And a lot of the concerns are there seems to be a sort of an ignorance, just because they haven't lived it, between those two lifestyles, between those two priorities. And one thing that I have noted, especially with your firm, is that you usually have very good retention of your associates. And that seems to speak to you and Dave, really having kind of zeroed in on the right formula for the difference between the work and the life balance. Is that something that has kind of come innately, intuitively, or is that something you've worked on specifically?
I don't know about a retention. Matt is the exception, not the rule. How long have you been here, Matt?
It was announced at the beginning. Were you not listening? It was 10 years.
10 years.
It's
okay.
11 now.
10 years. How many people have you seen come and go in those 10 years, Matt?
A couple.
Yeah, maybe we shouldn't go there. But
the difference is this, right? Because what you do see, and we don't have to name any names, but there are plenty of big law firms which prioritize everything you talked about, Harry, in terms of making sure those billables are there, and they prefer to have people sleep under the desks, and a 6-day work week is sort of a light week, and you see a lot of churn, a lot of turnover in those firms, and I think a lot of especially younger attorneys coming into this, especially right out of law school, they get their law degree, their law license, they pass the bar, right, and now the question is, well, how do I actually do this job? And the question becomes, should I sacrifice my health, my life on the altar of that billable or whatever? Not everybody works on a billable hour structure. Or do you think that there's a better balance to be struck?
I mean, here's the problem. When you start out, no matter who you are, there's no substitute for time. And what I mean by that is, you got to put in the time learning. They teach you everything in law school except how to practice law. So there's no substitute for putting in the time to learn to practice law. Like I said, I tried a lot of small cases, small claims, evictions, things like that when I was a younger lawyer. And, but that did take time. I didn't sleep under the desk. But I can remember like one of my first trials, I spent the week before the trial, just studying up and boning up on how to try a case. Now what's that thing I do at the close of evidence? Is that a motion for directed verdict, or is that for is that a motion for involuntary dismissal? Oh, makes a difference if it's a jury trial or a non-jury trial. Okay, and I would spend an entire week just trying to figure that out. Well, of course, as I'm doing all that week, that means other things are not getting done that I'm going to have to do later. So there's no substitute for that time for doing those things, because there's not enough hours in a day to learn it all and do everything else too. So you're going to have to give some priority, at least initially, to that and learning those things up front. But, eventually, after, say, 10 years, one of the guys I worked with, one of the senior partners, said, it took me 10 or 12 years just to figure out what the heck was going on and what I was really doing. And then by the time I figured that out, I didn't want to do it anymore. Now, he continued doing it until he died at the age of like 80.
Well, that's the problem, isn't it? Because every time you ask any lawyer whether or not you should get into the profession, what's the answer?
Well,
don't do it.
I tongue-in-cheek say no.
Well, that's the. I know for a fact that
my children are lawyers.
Do as I say, not as I do. So, this. It sounds, Harry. It sounds a lot like it's less about the specific amount of time and more about recognizing, especially for that newer lawyer, when they've reached the burnout phase and saying, "Okay, I need a break."
Well, yeah. I mean, I say there's no substitute for time, but by the same token, if you spent, certainly if I'd spent all of my time sleeping under desk and things like that and staying at the office overnight. Now, that doesn't mean haven't been times where I didn't work until midnight or 1 o'clock or 2 o'clock in the morning. But I didn't do that week after week after week. I didn't work 7 days a week. And the lawyer I'm thinking of who said he never took a vacation in 14 years, I also know he worked 7 days a week. And I could not do that consistently without getting completely burned out and not being of any use to anybody. I also had triple bypass surgery 3 years ago. So, I often wonder if I had been that guy, would I have lived long enough to have triple bypass surgery when I was 62? Right.
So now, and kind of segueing here, because there's a lot here, right? We're gonna touch on a few subjects, but certainly there isn't any substitute for actually having someone that you can kind of, like Matt has with you and Dave, kind of, pairing up with, I suppose, is the best way of describing it. It's my understanding that the Florida Bar is implementing some programs or has implemented some programs that kind of focus on that. Now, I've heard one of them called Counsel to Counsel. Is that something that you've had any involvement in or familiarity with?
I have not. I've seen those programs.
Okay.
And
these are the ones where the idea is to try to take, the outside of the framework of your firm, take the new lawyer and sort of pair them up with the seasoned practitioner and try to sort of give them that real-time ability, that resource to sort of ask a question. Do you think there's value in that?
Oh, yeah, absolutely. And although I have not formally been involved in that program, I have heard of it. I've seen some, things come through on email. There's one local lawyer who was in the Claremont area who actually worked for a lawyer that's pretty close to my age and experience. And he would call me periodically with questions and whatnot. And he said, Joe Sr. told me I should call you if I have any questions.
Someone pawned it off on you, in other words.
You know these things, which I thought was a nice compliment, sort of. But I've never hesitated, and he's not the only one that's done that over the years. Although he's the only one that ever said my senior partner told me to call you, because you know it better than he does.
That's kind of a compliment. That's pretty high praise. It sounds.
Well, that's how I felt, but I've never hesitated to take those calls and to help with those kinds of questions and whatnot. Sometimes you run into some very interesting problems. That same young lawyer had a case one time where people had bought homes next door to each other and had moved into them and had lived in those homes for 10 years. And it wasn't until one of them went to refinance their mortgage that they discovered they had been living in the wrong house for 10 years.
Whoa.
Their legal description matched the house next door. And the occupant of that home, their legal description matched where that person was living. It's one of those cookie cutter neighborhoods where all the houses looked alike. And on moving day, they'd shown up and said, this is the right house number, and moved in. Well, there was some odd circumstance where like two house numbers that were very close to each other were right next door to each other, but one was like, Sandy Lane, and then the other one was Joe Lane. And so they had moved into the wrong homes. I probably never would have run into a case like that. I hadn't talked to that guy.
Right. Yeah, fair point. Now, Matt, I wanted to kind of talk to you from the mentee side. Now, you've been practicing over a decade, but let me ask you this. Do you feel like you're still a new lawyer?
When I talk to Harry, yes. That's the short answer, is that he has run into situations and has answers and examples that I can borrow from at any point and go, wow, he'll always know quite more than me on all of that, but I'm lucky to have that well of knowledge to kind of dip into on any situation that arises for me.
So let me ask this. It's a little bit of a pivot. Do you find any value in talking to your contemporaries, essentially the class, so to speak, give or take a year or two, that you entered the legal practice with? Do you find that acts in any way as a supplement to the more traditional sort of mentor-mentee relationship?
I think so. I think of a couple guys that I would speak to about things that are going on that probably maybe I wouldn't talk to Harry about. Not just like a technological question, Harry, but I probably want to go to you for Zoom advice. But for other things, just for being at the same level maybe of your career or at your firm, and talking about things like that. Maybe lawyer knowledge or just law firm knowledge, along those lines. That is something I think I will have you know
I am pretty technologically advanced.
Harry's actually pretty good technically.
And for the record, first on this call. Well, kind of same question you, Harry. Now, with the time you've had in the profession, do you still, when was the point where you stopped feeling like a new lawyer, whatever that may mean? To give some light at the end of the tunnel for those who are entering the profession, to give them an idea of kind of hey, after this many years or this many...
I don't know if my answer is going to be light at the end of the tunnel. I started practicing in October of 1986, so I was 26 years old. And actually, it's kind of funny because I was telling everybody when I was 26 years old and I would meet with a client, and I think this is a change in the culture. I would meet with clients that were 20 years older than I was, and they would say, yes, Mr. Hackney, if that's what you think I should do, then that's what I'll do. And in retrospect, I'd never been in a courtroom. I didn't know what the heck I was talking about. But, these people who were 20 years older than I was were taking my advice. I had one case in particular where the client was a man in his 50s that if he wasn't a billionaire back then, he was probably worth in excess of $100 million in the mid-1980s. And I can remember sitting in his office at one end of a big conference table, and he's in his 60s at the other end of the big conference table, and around us are these grizzled automotive veterans in their 40s and 50s, and they're all listening to me, about a federal court suit. I'm like, I look back on that and I think, my God, they were crazy. And again, I don't know that you would get that experience at the age of 26 or 27, like I did back then. But, I hate to say it, I was probably 50 before I got the feeling that, and I think it was about the time I started turning gray that I started to get that sort of feeling of, and it's not that I felt like I was new all those years. It's hard to feel new for 25 years. But, I started getting that point where I looked like the graying, wrinkled veteran lawyer. And
practice-induced grays, I think we call those. Practice-induced.
And I think part of that, too, is it's hard to describe. I guess the way I say it is maybe people start taking you more seriously because you look the part.
I remember you and David tell me that when I first started, when I had those feelings of like, I can't provide advice to these people. Like I'm too new. And then I remember you guys saying, once you get the gray hair, you'll at least have the confidence to playing the part you're already playing, and it helps.
Yeah.
Now, but wait, Matt, you now have two children.
I don't have the gray hair. I'm just losing the hair.
My question is, how do you apportion it? Which grays are apportioned to fatherhood and which grays are apportioned to the practice of law? I don't know how I'd answer.
The heart condition, I think, is the law firm stuff. I think that's more, that keeps happening. Yeah.
Well, now here's a question for either of you, but I'll start with Harry. Do you think that new lawyers, coming out of law school, first year, second year, third year out of law school, haven't gotten their law licenses, do you think they should start solo practices that early in their career?
Okay. First, I'm going to go very quickly back to what we just talked about, which is, for the first 10, 15 years, you feel like you're drowning all the time. Like you can't possibly get it all done. And interestingly enough, there was a former judge, Jerry Lockett, here in town, and went off the bench and then went back on the bench. And another lawyer in town was telling me that when Judge Lockett applied to go back on the bench, they asked him, they said, Jerry, did you learn anything in the years that you were off the bench? And he looked at him and he said, yeah, I learned that no matter how fast I bail, there's always more water coming over the transom. And the first 10 or 15 years, that's how I felt. And I think probably how most people feel, or if you don't feel like that, maybe you should. And then as far as, should you go right into solo practice? My short answer is no. My long answer is hell no. But, I think back, and I went solo after about 11 or 12 years of practicing law. I was solo for, I think, about 11 years. And it's hard for me to imagine going solo any earlier than that. Because I just can't imagine knowing as little as I did back then and not having any other individuals around me. And you got to keep in mind, it's not just the partners, it's the other associates in the firm. Because being in a firm with several associates, you could also go to the associates or younger partners if you had a question or needed some sort of advice. And I could concentrate on learning how to practice law without concentrating on the business of practicing law. And as a solo practitioner, you're in charge of the business of practicing law as well as the practice of law. And, you're not just a lawyer, you're a business person too. And just the business part of it could practically be a full-time job. And, you just, even if you're not running the business yourself, you're learning about regular billing and trust accounts and, things like that. There was a new lawyer here in town years ago, who shall remain nameless. And I was leaving the courthouse one day in my Oldsmobile Achieva, and I see him getting into his Mercedes-Benz 500S. And I think, wow, where did he practice before he moved to town? Because he's new in town. He's driving this big Mercedes. And, this is back when nobody in Lake County drove a Mercedes. And so I happened to speak to his assistant a couple of weeks later. And his assistant was a former secretary of mine. And during our conversation, she made mention that he was, quote unquote, just a baby lawyer. And I go, what do you mean by just a baby lawyer? And she goes, well, he's been practicing for 2 years. I said, 2 years? And he drives a Mercedes-Benz 500S? She goes, oh, yeah. And she goes, and he bought me leased me a SUV. And he gives me weekends at his condo on the beach. And he bought his wife this big fancy custom van. And I'm sitting there going, wow, what am I doing wrong? Well, he was disbarred within another year or two. And it turned out that what had happened was, he had a full page ad in the Yellow Pages, in case you don't know what those are. used to be a phone book we would get, and the Yellow Pages ad cost $10,000 a month for a full page. And personal injury lawyers could afford that, but your average general practitioner could not, which is what he was. And he had this big Yellow Pages ad, and people would come in to see him for divorces and things like that, and he would get like $1,500 up front as a retainer. So all this money came in, and he thought he was rich, and he would spend it as fast as he got it. Well, then he didn't realize that you send out the bills and you don't get paid right away. That they didn't necessarily have another $1,500 or $2,500 in their pocket. That the waitress he was representing in her divorce had borrowed that $1,500 from her mother, and that was all the money mom had. And so consequently, now he's got all these, he's having to constantly maintain this churn of new clients, and he's not getting paid on the old clients, and he's trying to juggle all these balls. And of course, he couldn't do that, and he ended up letting a lot of the balls fall, getting in trouble with the bar. He was accepting retainers right up till the day he got disbarred, knowing that he was never going to be able to perform that work because he was on the path of disbarment. That's an extreme example, I think, of what can happen if you don't understand the business of law. And
that raises a really good point.
Realize that it wasn't one of those things where you send out a bill and they immediately send you a check. You have to manage your cash flow and your client expectations and the payment of your bills and those sorts of things. And he didn't have any clue about any of that. So that's just one example of why I don't necessarily think it's a great idea for you just to go straight from law school to the practice of law, because you might have a pretty good idea of where to look things up and how to figure it out for yourself. But it's certainly not when I went to law school. They didn't spend any time on the business of law at all. I think they do now, but
it raises a good point because all
years ago.
Well, because all of this stuff effectively is intertwined, right? I mean, you talk about things like time management, you talk about things like what you just described, taking on essentially more work than you can handle. And of course, that touches on the question of knowing when to say no. I think especially when you look at the solo practice, the temptation, I think as you kind of referenced, is take every case that you can get, forgetting, of course, that you might have to be in 3 different counties at once if you're not careful.
Yeah, knowing when to say no is as important a skill as getting the cases in. And when the rent's due, or you've got a mortgage payment to make, and somebody's sitting in front of you with a case you just really shouldn't take, but they've got a check in hand for $2,500, it's very tempting to take that case. But the other thing that can happen is, if that money should go into trust, and you're taking it, paying your mortgage payment, well, you could run into problems with the bar there too.
Would definitely run into problems with the bar.
I used to sit on the client security fund committee, and we would see those things from time to time where, maybe they took the money in good faith, intending to do the work, but they didn't do the work right away, and then something happens, and they've already spent the money.
Yes, I see your point. You got to be careful with that. Now, it kind of segues to just another question I'd written down as you were talking about this whole thing, because it's nuanced, right? There's a lot of different moving parts to the practice. What advice would you give to newer attorneys on how to both identify with stress and then cope with the stresses of the practice?
Don't drink. I say that flippantly, but a lot of lawyers do have drinking problems, and I always joke they taught us how to do that in law school. I've never been a go home and have a cocktail kind of a guy. I mean, I'll go weeks without a beer or any alcoholic beverage, but not that I'm a teetotaler. I just never figured that was going to solve any of my problems or actually make things easier. It might temporarily take the edge off, so to speak, but long term, it's not really going to help you. And I think for me, it's recognizing, it's recognizing that you can only do what you can do. And once you've done everything you can do, it's out of your hands, so to speak. I had a jury trial in West Palm Beach one time, and one of the lawyers that rented office space in my office had been involved in the facts leading up to the case, which how I ended up with the case. He referred it to me that he was going to be a witness. He couldn't get a hotel room. Apparently, there was a big football game or something in South Florida, and so he ended up in my hotel room. And, he was telling the story later. He said, Harry's sitting there, he's reading transcripts and he's getting ready for cross-examination. He's making notes and all this. And he goes, and at 11 o'clock, he shuts everything and goes, time for bed. Turns out the lights, his head hits the pillow, and 5 seconds later, he's asleep. He said, I would have been up all night worrying about it. And I said, well, Roger, the thing is, once I've done everything I can do to get ready for the next day, the best thing I can do is sleep. The best thing I can do is be well rested so that I'm alert and ready to try the case next day. And I think, some of that is, again, there's no substitute for experience. Some of that is over the years having recognized that, I could deal with things on my feet. I could, adjust as necessary, that I had that skill and that ability, and that the best I could do is get as prepared as I could. I would cope, but in order to cope, I had to also be well rested.
That's an excellent point.
I think it's kind of recognizing your limits and, recognizing in yourself that, you can only do what you can do. Once you've done everything you can do to prepare, then it's not in your hands any longer, but you can sleep well knowing that you did what you could. And I think what happens is, and I have a tendency to do this too, I think we all internalize the idea that if my client didn't win, it's my fault. I could have done more. I could have done something different. And, I think it was F. Lee Bailey that said that 90% of any case is the facts. And, I forget the exact percentages, but let's say 5% of it's the law and the last 5% is the lawyer. And F. Lee Bailey, reputedly one of the great trial lawyers of our time, had that attitude that, 90% of the case was out of his hands. It was the facts. And, he stands out for his cross-examination of Mark Furman in the O.J. Simpson case is the thing that everybody's familiar with. But you got to understand that F. Lee Bailey looked that fabulous in that trial because of money and time. Because they had the money to hire private investigators to spend the time digging up dirt and information on Mark Furman. And most of us don't have $1 million budgets and armies of private investigators. But, at the end of the day, it was that preparation and that level of resources that made him look brilliant in that particular case.
So just do everything perfectly at all times is basically what you're saying.
In that story that Harry told Zach, I would have been up all night because I would have had the mentality of I've not done everything I can because I can continue to churn. I can continue to worry myself silly until I have done literally up to the minute. Like reminds me like a law school exam. I would be cramming that right until the start of the test because there's always more that I could try to digest. I don't think I've got the discipline to go ahead and say, just turn off my brain and go, hey, you did fine. I think there's always a point.
So that's it. I'm going to say something controversial here because as Harry was mentioning this, first of all, I agree. And I don't have, even a scintilla as much wisdom as you do, Harry. But the first time I remember realizing that was ironically not in law school, but in fact in preparation for the bar exam where, you've been cramming and cramming and cramming and you think that the night of you're going to somehow cram more when of course there's this reality that there is a saturation level that's reached as far as how much information your brain is capable of processing. And it actually sounds like that might be one of the first times that you sort of learn how to actually practice law is right then and there the night before the bar exam. What do you think?
Well, in law school, I would study and study and study right up until the moment of the exam. And then I would take my sandwich for lunch to the exam with me. And I'd get to the exam room and I'd sit back and put my feet up on the desk and kick back and eat my tuna salad sandwich. And one of the other students in my class, he looked at me, he goes, "How can you eat at a time like this?" He goes, "We're about to take this exam and you're sitting there eating the sandwich." I'm like, Rich, I did everything I could, until I left home. I said, now I'm hungry, so I'm going to eat.
But it makes sense, right? Because you're hitting on something that's very, very, it's a product of experience. It's the recognition that it doesn't matter how much you wish you could know more. The F. Lee Bailey quote exemplifies the point that the testimony will be what the testimony is, and you don't know what to expect, no matter how many outlines you've made. But conversely, and this is where it's a very nuanced message, the burden of every good lawyer is to be prepared. So it's not you can slack off and wing it. It's a acceptance that once you've done the hard work, there is a limit, and then you have to throttle back, or else you're going to compromise yourself physically. You're not going to have enough sleep. You're not going to have enough food.
I was, I used to think, and this is part of it too, I used to think trials were like plays. That by the time you got to trial, you had everything scripted out. Because, you should know never to ask a question you don't know the answer to. And, you should have deposed everybody and know exactly what they're going to say. And, of course, that shows how naive I was, because no matter how much time you spend deposing them, you get to the trial and there's a whole different twist. Yeah. On what they say, or they come up with something you never thought to ask them. But so I used to think that they were like plays. And I think it was actually the seminar that I went to one time and I think it was one of the, foundational seminars, where one of the lawyers, who's a very good trial lawyer in personal injury cases, had a case where, this expert's testimony had been devastating as to how the accident had occurred. And it involved like chlorine in the trunk of a car that had exploded or something. And this expert claimed, well, it was because they had put this canister of chlorine or whatever on top of this battery that was in the trunk. And the guy said, it was right before lunch and I was devastated because I go to lunch and I happen to have one of the canisters of chlorine and I happen to have a battery. And he goes, I kept trying to get it to work the way the expert described it. He goes, no matter what I did, I couldn't get the canister to stay on the battery long enough for it to have caused the reaction he claimed happened. So he said, after lunch, I go back to him and I go, I get to cross-examine him. And I said, explain to me how, he said, because I tried it at lunchtime and I can't get this to work. He goes, oh yeah, neither could I. He said, well, what do you mean? He goes, oh, yeah, I had to tape them together.
Well, there you go.
I couldn't. Yeah, you don't know what to expect. I had to tape them together to get them to stay. Well, of course, that was the end of that expert and end of his worry about the case. But, to me, that demonstrated that it wasn't a trial. I mean, that it wasn't a play, that the script was never written until you were done. And that, yes, going back to the theme of preparation, he'd done what preparation he could, not knowing that this was going to come up in trial. But, he was prepared from the standpoint that he had gone out and bought the canister of chlorine or whatever it was and bought the battery and had them, had worked with them and had them available at the time. But, again, I learned it's not a play. You're never going to know everything, and it's never too late to keep working at it. But sometimes that working at it comes in the middle of the trial. And then flexibility and ability to go with the flow is what's going to matter.
My professional mentor, James Hope, he told me he was board certified as a criminal defense attorney, still is. And he told me, one of the techniques that he'd used was make sure you touch every piece of paper in the file. It's not to say that was the end of his preparation, but if you can say to yourself, I've touched every single piece of paper, I've looked at every transcript, I've looked at every exhibit, I've looked at every document that would be relevant, then you've got a decent idea of you having prepped at least to the point where you would be able to speak cogently on it.
That's very true.
Well, now look, this has been fun. I'm shocked to see that we're rounding out on an hour here. So it seems like we could probably spend many more hours talking about this. And candidly, maybe we should look at the idea of doing a follow-up. But to kind of put a head on it today, given that we're talking about this whole presentation in the context of the mentor and mentee relationship. If you had to, and I realize I'm putting you on the spot, but if you had to, what's the best little bit of advice that you could give newer lawyers?
Well, yeah, I'd have to say don't be afraid to reach out and try to develop that relationship with somebody, whether it's in your firm or outside of your firm. You know, particularly with somebody outside of your firm, you don't want to be a pest, but by the same token, you might be surprised to find that the other person, the more experienced person you're reaching out to develop a mentor-mentee relationship, might actually appreciate it because, you know, sometimes those discussions help you, you know, work out and form ideas in your own mind. But, you know, honestly, sometimes I sit here and think as I'm approaching the end of my career, I mean, realistically, how much longer am I going to do this? Another 10 years? You know, I keep saying I'm going to go to the 50-year bar lunch and walk in a practicing lawyer and walk out a retired lawyer. But I'm going to go to that 50-year lunch still a practicing lawyer. But, you know, that's 10 years from now. And, you know, I think, will I have passed along what I've learned, or is it going to die with me? And, you know, from the standpoint of mentoring somebody, you know, I'd like to think it doesn't die with me, that I've passed along some of what I've learned over the years. And, you know, the mentor gets something out of it as well, which is advice to mentors, but also it's advice to people that are looking for that relationship that, you know, I know you're thinking you don't want to be a pest, et cetera, but that person might appreciate it and might actually get something out of it themselves. So don't be afraid to reach out.
Don't be afraid to reach out. It's good advice. Well, Matt, Harry, I really appreciate you coming on. It's been entertaining, insightful. I enjoyed it, and I'd love to do this again sometime if you're up for it.
Sure.
Absolutely. Thanks for moderating, Zach. Yep. Appreciate it. Thank you, Harry.
We'll talk soon. So.